Yes.
Okay. Next item of business is another guest that we have. The commission has been tasked with developing guidelines under Act 29 of 2012. Act 29 establishes the State Military College Legislative Appointment Initiative Program. Under the program, each member of the General Assembly may annually appoint an eligible student who is a resident of the member's legislative district for guaranteed enrollment in a state military college. Such appointments must be made at the sole recommendation of a selection committee created by the member. The commission is to develop guidelines to govern the establishment and functions of the committees to help ensure that the committees and the legislative appointments do not create any conflicts of interest or otherwise violate the Ethics Act or the Legislative Code of Ethics. We anticipate that the commission will have draft guidelines to discuss at our next public meeting. We have received some helpful background information from the chair and vice chair of the House Committee on Ethics regarding the guidelines which that committee promulgated under an appointment program instituted by the House resolution before Act 29 was enacted. Today, we will hear brief remarks from Dr. George Anderson, Legislative Liaison to the Valley Forge Military College, who has been involved with this issue. Dr. Anderson, please state your business address, and we'll look forward to hearing from you.
Thank you, Mr. Chairman. I'm Dr. George Anderson. Valley Forge Military College and Academy is at 1001 Eagle Road in Wayne, Pennsylvania, 19087. And you should all now have copies of my remarks. You should also have in the folio that was handed to you, thank you very much, a copy of the House Ethics Committee guidelines, which governed House Resolution 565, the predecessor to Senate Bill 560 and Act 29. Ladies and gentlemen, I wish to thank you for allowing me this time to briefly review the history of Act 29, the significance of its impact on Pennsylvania students, and the importance of Valley Forge of maintaining the highest ethical standards this commission sets forth. The Legislative Appointment Initiative started in 2009 with the passing of House Resolution 565. At that time, I was told the House Ethics Committee reached out to this committee, this commission for guidelines and guidance, and the results are included. Senate Bill 560, or Act 29, 2012, placed the Legislative Appointment Initiative into law. Within this commission's standards, each senator and representative of the Commonwealth has the ability to appoint one student per year to Valley Forge Military College, the Military College of Pennsylvania, so long as the student receiving the appointment meets the academic guidelines set forth by the college. The student is guaranteed admission and guaranteed the largest scholarship the school can provide. As clarity, the school is an independent, non-state institution, and there are no state funds involved in this. This scholarship is provided solely by the school. What will this program mean to the students of the Commonwealth? Over the last several years, the federal representatives of Southeast Pennsylvania have held their Academy Night at Valley Forge. Those students who are interested in attending West Point, Annapolis, Air Force, come to an Academy Night where they receive more information, and the staffs of the representatives can have a better look and interchange. On those evenings at Valley Forge, just in the southeast corner, we receive 300 to 400 students looking for appointments to the federal military academies. It's quite a lot of young, dynamic individuals who are trying to do the right thing and serve their country. If we extrapolate that out over the Commonwealth, somewhere within this Commonwealth are 1,500 to 2,000 students each year who wish to serve their nation and, quite frankly, probably are looking for some financial help in their education. A significant number of students. Unfortunately, the federal institutions are highly limited in the number. They are the most desirable institutions, arguably, in the world, and even the best students are only marginally likely to get in. Maybe a handful from the Commonwealth get into those schools each year. We fully understand that. At Valley Forge, a two-year institution, a young student who, in fact, wishes to attend the school, wishes to serve their country and get financial help, has the opportunity of becoming a second lieutenant in the United States Army within only 2 years. At risk, I say, West Point takes 4 years to build an officer, Valley Forge only takes 2. I'm not sure why that is. That's not the written statement.
That's what the Army does, right? Not the Navy.
It's Army guys, unfortunately. Yes, unfortunately, the Army is the only one with such a program.
For the record, I'll state it took me 4 years.
It took me 5. While Act 29 passed overwhelmingly in both the Senate and the House, some elected officials appropriately expressed concerns about the ethics provisions and potential abuse. If there is one message I can leave with you today, it is the absolute concern and absolute dedication of Valley Forge to maintaining the highest ethical standards within this program. It is in our organizational best interest to do so. The program has the ability to serve Valley Forge for the next century, maybe longer. We know West Point and Annapolis as the great institutions they are. Nobody remembers the West Point that existed for the first 20 years that no one wanted to attend, that, you know, everybody, you know, it was like being sentenced to the furthest frontier. It is what it is today because of its relationship with Congress. And this is a game changer for the school, but it will only be so if the highest standards are maintained. There is one provision I would request the Commission add to their considerations of the House provisions. House provisions are perfectly adequate in my opinion, with the exception that an affidavit letter signed by the representative or senator be submitted with the packet to Valley Forge, attesting to the fact that all the provisions set forth by this commission have been complied with. If that is made a matter of record within that administrative process, there is personal accountability for the process, and therefore, quite frankly, I think the process would be much more secure. I thank you very much. I hope I was brief enough and not excessively glib. I welcome any questions that you may have.
Dr. Anderson, thank you very much. There's the one sentence in the law that involves us, but it's so important. And for our fellow commissioners, we are charged with coming up with the guidelines, which we will do, and if we appreciate your recommendation. But this says the State Ethics Commission shall develop guidelines to govern the establishment and function of committees to help ensure that the committees and the legislative appointments do not create any conflicts of interest or otherwise violate them. So we will work with you and be happy to work with you. And Ms. Hiddy, do you have anything to add?
I just have one quick question. On your suggestion, which is, it's great to get the practical suggestions, do you think it would make sense not only to have the legislator sign such a letter, but also the members of his or her committee?
I don't have enough background
Okay,
to respond to that intelligently.
okay.
Valley Forge, I know that when I put my name on a piece of paper, I try to make sure that, I double try to make sure that it's absolutely correct. I've been told some people question whether phones and, you know, what I've just heard. By having the legislator or the senator representative sign that the process has been complied with, I think takes it up a notch and makes the whole thing more secure.
I have a question. I want to make sure that I understand this. So you're saying that every legislator, every House member, every Senate member has the opportunity to nominate one person to Valley Forge Military Academy. Is that right?
No, sir. Within this act, they have the ability, different than the federal, it is reflective of the federal program, where representatives nominate. The schools select from the nominations. Within Act 29, the representative or the senator actually appoints for guaranteed acceptance and guaranteed scholarship.
And how much of a scholarship and how many years? Is it 1 year?
It's a 2-year scholarship, and it varies somewhat by academic standard. A student with a 3.5 would receive approximately a 50% scholarship. A student with the bare minimum of a 2.5 would receive basically a third of the school,
Okay.
of the total overall cost of attendance.
Okay.
I tell people we have fashion consultants at Valley Forge. They're called sergeants. They tell them what to wear every day.
Commissioner Volk, you have a question?
No, I don't have a question, but I have well, I will ultimately, but my comment is first that I applaud the college in this way of giving individuals, students an opportunity first to go to college and then to seek a commission in the Army. My question will come later when I talk to you as now a college president on how you're funding this. I face those same challenges. So we can talk about that offline and not on the record.
Yeah.
And I should say, for those students who are seeking, because this can apply to anyone, for those students who are just seeking the education, it's a third to a half of the cost of the school. For those who are accepted into the early commissioning program, it is functionally a full boat scholarship.
Sir, does the scholarship include, or what does it include, the education part, but how about housing, food, things of that sort? Because I know they live on campus.
Yes, absolutely. At Valley Forge, the total cost, when Harvard or the University of Pennsylvania says tuition, they mean the right to sit in a classroom. When Valley Forge says tuition, we mean the total cost of attendance, including the fashion consultants, the sharp-looking uniforms. So it's about a third to a half of that total cost of attendance.
Are women accepted at Valley Forge?
Absolutely, at the college.
What is the total per year?
The total cost of attendance is approximately $40,000.
How many students are in each class, out of curiosity?
In each class?
Yes.
We have approximately 300 total in the college. The freshman class is always a little larger. We do prepare students for West Point, Annapolis. So we lose about 40 of those going in, and we'll lose another 10, 15 who just don't want to come back.
So if there are 300 in the class, potentially you could have 253 more coming in. from
That's
the freshman.
absolutely right.
Okay.
That's absolutely right. As I said, it is a game changer for Valley Forge.
Yeah.
The commandant looked at me and said, "What do I do if they all accept this?" And I said, "Not my problem, boss, it's yours."
It'd be a good problem to have.
It'd be a good problem to have. this in a very real way. Usually when someone comes in and says, I want to have a government-private enterprise working together, it means it's going to cost a lot of money for the government. This costs the Commonwealth not a dime.
Any other questions for Dr. Anderson? Okay, thank you very much for
Thank
coming
you very much,
today.
Mr. Chairman. Thank you, ladies and gentlemen.
Okay. We'll allow the ordinary today because we had several guests, so we'll get back to the agenda that you have in your books. And we'll start with, the first case would be Connor, and I think Commissioner McCurdy, oh, excuse me.
Sorry, Mr. Chair, I think we might have in the audience one or more people involving the opinions, and it would be helpful if we know that. You might want to take them first so they're not held up.
Is anyone here, Zurchin? Klovinsky? Oh, so, okay, so you want me, okay, all right. Okay. Nick, I think you have the sign
Oh,
here.
you want to say something?
Yeah, well,
It's in there.
I'll make you time. So just, yeah. Why don't you come forward, please, and sit here.
The appellant in this case is Scott W. Klovinsky. Mr. Klovinsky is employed as a motor carrier enforcement officer with the Pennsylvania State Police. Mr. Klovinsky's position is under Job Code 70751. Advice of Counsel 12-554 was issued to Mr. Klovinsky on August 2nd, 2012. The advice determined that in his capacity as a motor carrier enforcement officer with the Pennsylvania State Police under Job Code 70751, Mr. Klovinsky is a public employee subject to the Ethics Act and the regulations of this commission, and in particular the requirements for filing statement of financial interest pursuant to the Ethics Act. Mr. Klovinsky appealed advice of Counsel 12-554, but did not state any particular basis for the appeal or submit any additional facts. Mr. Chairman, I would suggest that this would be an appropriate time for any interested parties to speak on this matter.
Mr. Kaminsky, floor is yours.
Good morning, Council. I appreciate your opportunity to speak in front of you. I really didn't prepare anything to talk to the council about other than the advice of council that I received on August 2nd. I basically showed up just to see what was going to be said, and I'm kind of humbled in front of you. I obviously didn't dress appropriately, and I don't disagree with Miss Heidi about the advice that she gave. I'm just kind of curious why I have to fill out that form. I have nothing to hide, but myself and my co-workers are kind of scratching their head because the Pennsylvania State Police, when we were taken over by PennDOT, when PennDOT gave us up and we were taken over by the State Police, we didn't really have anything to fill out such as this, and I'm not sure, our job description changes constantly and has never really been updated, and I said that I would sit in front of you all to find out exactly what, I'm used to talking in front of magistrates, so I apologize for my non-legal jargon.
Absolutely no problem.
So I'm just here to hear the discussion with council, that's all.
This is a appeal request, right?
It is. Mr. Chair, may I speak for a moment?
Yes.
Just by way of explanation, a little background for you. And I know it's set forth in the advice, but that can maybe be legalese to some
Yes.
folks.
Yes, ma'am.
The decision of who has to file one of these forms is based on what we call objective sources, which include the job description, job classification specifications. And sometimes we'll hear people say, well, I don't really care what the documents say, here's what I really do. There's case law, court decisions that require the commission or uphold the commission's approach of going by those objective documents. And when I authored the advice of counsel that was issued to you, it was based on the documents and certain key responsibilities that they contain. So I hope that helps.
It does, it does.
Mr. Costa?
Oh, sorry. I was just going to thank you for taking the time out of your schedule to come in and
Oh, thank you.
sit through what you've sat through this morning and appear before this board.
Very interesting, very interesting.
Fascinating.
It doesn't take too long to fill out the form.
No, it doesn't.
Commissioner Caulfield, do you want to complete?
Yes, Mr. Kaminsky. Mr. Chairman, I've reviewed the facts and relevant statutory provisions. As the commissioners are aware, we must apply the judicially approved objective test to Mr. Klavinsky's duties as set forth in his position description and job classification specifications. Having reviewed Mr. Klavinsky's position description and job classification specifications, I agree with the advice of counsel. Mr. Klavinsky's authority to perform the following duties brings him squarely within the Ethics Act definition of public employee. Perform technical safety, size, and weight, and hazardous material inspections of motor carrier vehicles and operations to determine compliance with and enforce state and federal motor carrier safety laws. Perform technical safety inspections of school buses. Select motor carrier vehicles for inspection and examine operating vehicle documents to determine compliance with safety laws. Perform technical inspections of truck and safety parts and equipment, and perform size and weight inspections of a motor carrier vehicle. Number 5, inspect compliance with the hazardous material transportation requirements. 6, determine inspection violations and use discretion to determine whether a traffic citation or written warning is issued and whether the violation is issued to the operation of carrier. And also my view that the other duties highlighted on pages 5 and 6 of the advice further establish Mr. Klavinsky's status as a public employee. Based upon my analysis and comments, I would like to make the following motion. I move that the holding of this commission in this matter be as follows. In his capacity as a motor carrier enforcement officer with the Pennsylvania State Police, under Job Code 70751, Mr. Klavinsky is a public employee subject to the Ethics Act and the regulations of the State Ethics Commission, and he is required to file statements of financial interest pursuant to the Ethics Act. The appeal is denied. Advice of counsel 12-554 is affirmed. Mr. Chairman, I move that the holding of this commission in this matter be as follows and be approved.
Okay, you've heard the motion. Is there a second?
Second.
Okay, it's been moved in second. Any questions, comments? Hearing none, all those in favor, please say aye.
Aye.
Any opposed? You're gonna have to fill out the statement.
Okay.
It's not it's not that bad.
Oh, no, I've done it before, I just
Okay.
was wondering why we do it, that's all.
Well, that's what I hope, our explanation. And tell me, are we ever gonna get seatbelts in buses?
Probably not.
Okay.
They are looking at them in other states, but right now Pennsylvania's kind of throwing that around, but they're thinking that they cause more damage than not having them on.
Hard to understand. I know that's not pertinent, but I'd be
I
glad.
appreciate your,
Just consider that.
yes, sir.
Just consider that you're a very important person, otherwise we wouldn't want to be looking into all these things, what you do with your time.
Sure.
So feel privileged.
I appreciate that, and it was just, I'm the type of guy, I just wanted to sit here and see what it was all about.
You might want to get a copy of what I read. It would be good on your resume.
Yeah, well, yes, sir, I appreciate that. Thank you very much for your
All
time.
right, thank you very much.
Thank you, sir. Thank you.
Okay, we're moving right along. Nobody here representing Connor? Anyone representing Xerxes? Okay, so we're back to actually number 1 on our agenda, which is Connor. And Commissioner McCurdy, you've been assigned that case. Please proceed.
Thank you, Mr. Chairman. I would suggest that this would be an appropriate time for any interested party to speak to this matter. Apparently, there's no one present who wants to speak up. Accordingly, I have reviewed the facts and relevant statutory provisions. Upon termination of her public service, Ms. Connor became a, quote, former public official, subject to section 1103G of the Ethics Act. Option one, based upon the submitted facts, it's my view that the submission to the charter school of a firm proposal responding to the RFP or other related documents from the firm would cause Mrs. Connor to run afoul of Section 1103G of the Ethics Act for engaging in prohibited, quote, representation before her former government body. Because Mrs. Connor is the majority owner of the firm and is aware of the proposed submission of such a proposal to the charter school, the submission of any such documents could not occur without at least Mrs. Connor's acquiescence, if not her express approval. Any documents submitted from the firm in response to the charter school's RFP would necessarily include Mrs. Connor's name and thus would have the inherent potential to influence the decision of the Board of Trustees of the charter school with respect to the award of a contract for bookkeeping services. Any invoices or bills submitted from the firm to the charter school for services provided under a contract between the firm and the charter school would likewise have the inherent potential to influence the decision of the Board of Trustees of the charter school with regard to making payments for such services. On my analysis, I'd like to make the following motion. Based upon the submitted facts, the firm's submission to the charter school of a proposal responding to RFP or other related documents from the firm would not cause Ms. Connor to run afoul of Section 11.
So we have two options.
Yeah, we know. I'm sorry for rereading this again, Mr. Chairman, if I may.
No problem.
Based upon the submitted facts, the submission of the charter school of a firm's proposal responding to RFP or other related documents from the firm would cause Mrs. Connor to run afoul of Section 1103G of the Ethics Act for engaging in, quote, representation before her former governmental body. Because Mrs. Connor is the majority owner of the firm and is aware of the proposed submission of such a proposal to the charter school, the submission of any such documents could not occur without at least Mrs. Connor's acquiescence, if not the express approval. Any documents submitted from the firm in response to the charter school's RFP would necessarily include Mrs. Connor's name and thus would have the inherent potential to influence the decision of the Board of Trustees of the charter school with respect to the award of a contract for bookkeeping services. Any invoices or bills submitted from the firm to the charter school for services provided under a contract between the firm and the charter school would likewise have the inherent potential to influence the decision of the Board of Trustees of the charter school with regard to making such payments.
Okay. Is that your motion?
That is my motion.
Yeah,
yes.
right, okay. Do I hear a second?
Second.
Okay. Been moved and seconded. If I understand this correctly, she has to sit out a year.
That's correct.
Yeah, okay. Everyone understand that?
It's a revolving chair or revolving door business.
Right,
We're talking about.
and it's our opinion that she has to sit out a year.
That's correct.
Okay, does everyone understand that? Okay.
Till next May.
Any more questions or comments? You've heard the motion, all those in favor say aye.
Aye.
Any opposed? Ayes have it. And we will proceed to the next agenda item. Zurchin, Mr. Commissioner Volk, I think you have that case
Yes, I
too.
do. Thank you. The requester is Cynthia R. Zurchin. She is the Assistant Superintendent for the Moon Area School District. Ms. Zurchin recently co-authored a book entitled The Whale Done School, which I shall refer to as the book. Moon Area School District School Board has approved the purchase of a copy of the book for all employees within the school district. The school district will be ordering a minimum of 500 copies of the book. Ms. Zurchin asked whether the Ethics Act would permit her to purchase copies of the book directly from the publisher, Author House, on behalf of the school district in order to pass along to the school district the discount that is available to her as a co-author of the book. Ms. Zurchin states that doing so would save the district $2,919.82, and that she would have no personal gain from the sale of such copies of the book to the district. Mr. Chair, I know we asked previously if anyone was present to speak on this issue, and I didn't see anyone come in, but I'll throw it out again. Is anyone here? Okay, seeing no one, Mr. Chair, I've reviewed the facts and the relevant statutory provisions, and it's my view that Section 1103A of the Ethics Act pertaining to conflict of interest would not prohibit Ms. Zurchin from purchasing copies of the book from Author House on behalf of the school district using her discount. Based upon the submitted facts, there would be no use of the authority of Ms. Zurchin's public position or any private pecuniary benefit to Ms. Zurchin in doing so. As for whether Section 1103F of the Ethics Act would apply, that would depend upon how the transaction would be handled. It is my view that an agreement or arrangement for Ms. Zurchin to pay Author House for copies of the book and then receive payment from the school district for the cost of the copies would fall within the Ethics Act's definition of the term contract and would trigger the applicability of Section 1103F. Under Commission precedent, the value of the contract would be based upon the amount paid by the school district to Ms. Zurchin and not the lack of any financial gain to her. However, if copies of the book would be ordered from Author House in Ms. Zurchin's name, but the school district would make payment directly to Author House with no payment flowing to Ms. Zurchin, there would not be a contract between Ms. Zurchin and the school district, and therefore the restrictions and requirements of Section 1103F would not apply as to such an agreement or arrangement. Given my analysis and comments, I'd like to make the following motion. I move that the holding of the Commission in this matter be as follows. As the Assistant Superintendent for Moon Area School District, Ms. Zurchin would be considered a public employee subject to the Ethics Act. Based upon the submitted facts, Section 1103A of the Ethics Act would not prohibit Ms. Zurchin from purchasing copies of the book directly from Author House on behalf of the school district in order to pass along to the school district the discount available to her as co-author of the book. An agreement or arrangement whereby Ms. Zurchin would pay Author House for copies of the book and then receive payment from the school district for the cost of the copies would constitute a contract as that term is defined under the Ethics Act. The value of such contract would be based upon the amount paid by the school district to Ms. Zurchin for the cost of the copies of the book and not upon her lack of any financial gain from the transaction. The restrictions and requirements of a Section 1103F of the Ethics Act would have to be observed as to any contract between Ms. Zurchin and the school district valued at $500 or more. Section 1103F of the Ethics Act would, at a minimum, require that any contract between Ms. Zurchin and the school district valued at $500 or more be awarded through an open and public process, including prior public notice and subsequent public disclosure of all proposals considered and contracts awarded. An agreement or arrangement whereby copies of the book would be ordered from Author House in Ms. Zurchin's name, with the school district making payment directly to Author House for the cost of the copies, and no payment flowing to Ms. Zurchin, would not constitute a contract between Ms. Zurchin and the school district, and therefore the restrictions and requirements of a Section 1103F of the Ethics Act would not apply as to such an agreement or arrangement.
Thank you, Mr. Bogue. You've heard the motion. Is there a second?
Second.
Second by Ms. Bergen. Any questions, comments? All those in favor, please say aye.
Aye.
Any opposed? Motion carried. Thank you,
Mr.
Commissioner
Bolger,
Bogue.
Mr. Bolger, can you hold a second? I need to change the tape.
I like the name of that school, that book, Whale of a School.
The whale then.
Well done, Marty.
Okay.
Okay, thank you. Next item on agenda, item 5, civil penalties, orders, consent, and default. Commissioner Bergen, I believe you have that.
Yes. There are 6 civil penalty cases with proposed consent agreements that are now before this commission for decision. These cases involve respondents J. Preston Lutweiler, Eric B. Springman, Ricky A. Nevins, Jarius S. McClendon, Kenneth Minton, and Scott Gilroy. The parties have submitted consent agreements proposing that the commission find that the respective respondent failed to timely file a statement of financial interest for calendar year 2010 and impose one civil penalty. Each of the respondents has paid the recommended civil penalty pursuant to the respective consent agreements and filed the delinquent form. Claire, are we okay? Okay. Based upon my review of the facts, I am of the opinion that these consent agreements are consistent with commission precedent and are proper dispositions for these cases. Based upon my analysis, I would like to make the following motion. I move that this commission approve the consent agreement submitted by each of the following respondents and the investigative division, imposing civil penalties for failure to timely file statements of financial interest for the calendar year 2010 as follows. J. Preston Luttweiler, $150. Eric B. Springman, $50. Ricky A. Nevins, $50. Jarius S. McClendon, $150. Kenneth Minton, $150, and Scott Gilroy, $150. And that is my motion.
Thank you, Commissioner Bergen. Is there a second?
I'll make the motion.
Okay, it's been moved in second. Any questions, comments for Ms. Bergen? Hearing none. All those in favor say aye.
Aye.
Aye. Any opposed? Motion approved. Next.
Mr. Chair, there's one more additional civil penalty default case that is now before the commission. This case involves respondent Mark C. Snyder, who failed to file a statement of financial interest for calendar year 2010. The respondent did not take action or respond to the civil penalty proceedings. Following review, it is my opinion that as the respondent, the commission should levy a maximum civil penalty of $250 for the delinquent statement of financial interest. It is my opinion that the commission should also order the respondent to file this delinquent statement of financial interest. There is nothing of record that would constitute a defense or excuse for his noncompliance. Based upon my analysis, I would make the following motion. I move that the commission levy a maximum civil penalty in the total amount of $250 against respondent Mark C. Schneider for failing to file a statement of financial interest for the calendar year 2010. Further, the respondent shall be ordered to file his statement of financial interest for calendar year 2010 within 30 days of this order. And that is my motion.
Thank you. Is there a second to that motion?
Second.
Been moved in second. Any questions, comments for Ms. Bergen? Hearing none. All those in favor say aye.
Aye.
Any opposed? Motion carries.
Excuse me, Mr. Chair, there was a last-minute addition to the civil penalty orders that were consents, and that was Erica Jones Fearbury, and it was added to the agenda. Okay,
Oh, sorry. Yeah.
Was that, okay.
One more addition.
Okay.
There's one more additional civil penalty case with the proposed consent agreement that is before this commission. This involves respondent Erica Jones Fabry. The parties have submitted a consent agreement proposing that the commission find that Ms. Jones Fabry failed to timely file a statement of financial interest for calendar year 2010 and impose one civil penalty in the amount of $150. Ms. Jones Fabry has paid the recommended civil penalty pursuant to the consent agreement. Based upon my review of the facts, I am of the opinion that this consent agreement is consistent with the commission and is a proper disposition for this case. I move that this commission approve the consent agreement submitted by Ms. Jones Fabry and the investigative division imposing a civil penalty in the amount of $150 for Ms. Jones Fabry's failure to timely file a statement of financial interest for calendar year 2010. That is my motion.
Is there a second?
Second.
Any questions, comments for Ms. Bergen? All those in favor, please say aye.
Aye.
Any opposed? Motion carried. Please continue, Ms. Bergen.
There are two additional administrative penalty cases with proposed consent agreements for our consideration. Respondents Orion Land Services, Inc. and Washington Advocacy Group on behalf of Charter School Management are principals who failed to timely file a quarterly expense report for the fourth quarter of 2011 in their capacities as registered principals. In each case, the parties are in agreement that the respondents' transgressions of the lobbying disclosure law was negligent. The respondents have already filed their delinquent expense reports. One of the respondents, specifically Washington Advocacy Group on behalf of Charter School Management, has already paid its agreed-upon administrative penalty. Based upon my review of the facts, I am of the opinion that the consent agreements are proper dispositions for the respective cases, and I would make the following motion. I move that this commission approve the consent agreement submitted by each of the following respondents in the investigative division and impose the following administrative penalties for the respondents' delinquent expense reports for the fourth quarter of 2011. As to Orion Land Services, Inc., an administrative penalty in the amount of $3,360, and as to the Washington Advocacy Group on behalf of Charter School Management, an administrative penalty in the amount of $3,920. And that is my motion.
Okay, you've heard the motion. Is there a second?
Second.
Any questions, comments from Ms. Bergen? All those in favor, please say aye.
Aye.
Any opposed? Motion adopted. We did the civil penalties default, Ms. Bergen?
There were, let's see, 1, 2, 3, 4, 5, 6, 7 other civil penalty orders consent under lobbying. Okay, that was-
That's, Ms. Bergen, thank you. Commissioner Kaufman, civil penalties orders, there's consent and there's defaults.
And there are 7 administrative penalty cases with proposed consent agreements for our consideration. The following 7 respondents are principals that failed to timely file a quarterly expense report for the fourth quarter of 2011 in their capacities as registered principals. WITF Inc., number 2, Joint Ammunition and Technology Inc., Pittsburgh Film Office, Planned Parenthood in Western PA, Charter School Management Inc., Allstate Development Company in South Fayette Township. In each case, the parties are in agreement that the respondents' transgressions of the lobbying disclosure law were negligent. The respondents have already filed their delinquent expense reports and are in the process of paying the agreed-upon penalties. Respondent Joint Ammunition and Technology Inc. has also agreed to file a notice of termination with the Department of State and to refrain from any and all lobbying activities in Pennsylvania for 3 years from the date of issuance of the Commission's order. The parties are free to contract to such items in a consent agreement. Based upon my review of the facts, I'm of the opinion that the consent agreements are proper dispositions for the respective cases, and I would like to make the following motion. I move that this commission approve the consent agreement submitted by each of the following respondents in the investigative division and impose the following administrative penalties for the respondents' delinquent expense reports for the fourth quarter of 2011. As to WITF Inc., an administrative penalty in the amount of $3,920. As to Joint Ammunition and Technology Inc., an administrative penalty in the amount of $1,600. As to Pittsburgh Film Office, an administrative penalty in the amount of $3,360. As to Planned Parenthood, Western Pennsylvania, an administrative penalty in the amount of $3,920. As to Charter School Management Inc., an administrative penalty in the amount of $3,920. As to Allstate Development Company, an administrative penalty in the amount of $3,360. And to South Fayette Township, an administrative penalty in the amount of $1,600. I further move that respondent Joint Ammunition and Technology Inc. be ordered to file a notice of termination with the Department of State within 30 days of the issuance of the Commission's order and to refrain from any and all lobbying activities in Pennsylvania for 3 years from the date of issuance of the Commission's order as the parties have agreed. I make this motion and hope for approval.
Okay, you've heard the motion. Is there a second?
Second.
Okay, I have a question. The chair has a question. Where does that money go? Do we get that part of our operating budget?
Goes into the general fund.
General fund of the Commonwealth?
Yes.
Because there's pretty big numbers there, as opposed to the smaller penalties that
The
are...
lobbying disclosure law has higher penalties for failure to file or delinquent filings.
Okay. And Commissioner Caulfield, these were consent agreements, right? Okay. All right, you've heard the motion in a second. Are there any questions or other comments? Okay, all those in favor say aye.
Aye.
Any opposed? Motion carries.
Mr. Chairman, there are 2 additional administrative penalty cases.
I think those were covered out.
Were they covered?
Yeah, I think so. I think we've got them all at this
It
point.
was on a roll.
Did the Orion Land Service and Washington Advocacy?
Ms.
Yes.
Bergen did.
Yep.
Bergen covered that.
Okay.
Sorry, Nick.
I was really
Don't mean to steal your thunder.
Yeah, I was really listening.
Get paid by the word.
Okay, we're winding down on the public meeting. Next item on the agenda, administrative matters. John and Robin, payment schedules and Act 29 guidelines. Act 29 was the, Dr. Anderson. You want to take that first?
There are no payment schedules to report, so we'll have to
okay.
write that one.
No payment schedules to report. Ms. Hayes?
The only thing I would add, of course, commissioners are aware that we have this duty, and my goal is to hopefully have, drafts for you to consider by the time of the next public meeting. That would be my goal.
Okay. Okay, thank you both. Number 11 on the agenda is a special election for vice chairman. Recall, under our operating procedures, when the chairman is replaced, the vice chairman automatically goes to chairman, and so we have a vacancy for vice chairman. At this time, I would like to entertain a motion. Any of you might have, Mr.
I'll
Kaufman?
make a motion to have Mr. McCurdy be the vice chairman. He served this commission very well through the years, and I think he deserves it.
Excuse me, Mr. Chair, before you get to the motion on who should be the vice chair, you and I had talked about an issue, and I don't know if it's something that you felt a need to bring up or
You're
not.
absolutely right, I apologize, I forget that, and
Read that.
let's,
Need a
Yeah,
motion to
uh,
suspend the rule.
Chair apologizes. Pursuant to the Commission Resolution 85002, notice of special election must be publicly announced at least 30 days prior to such election and forwarded to all members of the Commission. While the members of the Commission received more than 30 days' notice of the special election as scheduled for today, the public notice was 4 days short of the 30 days. In order for us to have the election today, in order so that we can proceed, we will need a motion to waive or suspend the requirement for 30-day public notice of the special election that is scheduled. This is a one-time deal, it's for this election. Somebody please make that motion that we suspend.
So moved.
Thank you.
And second.
Okay, moved and second that for this time, we suspend that regulation coming from our regulations, so we're 4 days short. So, okay, any questions, comments? All those please say aye.
Aye.
Any opposed? Motion carried. I'm very sorry I missed that, and so now we'll proceed. There's a motion on the floor from Commissioner Kaufeld to nominate Commissioner McCurdy as vice chairman. Are there any other nominations on the floor? Hearing none?
I second that motion for Mr. McCurdy.
Oh, it wasn't second, okay. It's been moved and seconded that Commissioner McCurdy be named vice chairman of this commission. Any questions, comments? All those in favor say aye.
Aye.
Any opposed? Congratulations, Mr. McCurdy. I will look forward to working with you.
Thank you.
I think. Okay, I think this would be, I think this would be a good time for a 5-minute break.
We need a motion.
Yeah, okay. You can tell I'm a rookie. I need a motion to adjourn the public meeting.
So moved. Don't call.
Second? All those in favor say aye.
Aye.
Any opposed? Motion carried. We will take a 5-minute break.
Maybe with a motion.